Get rolling here, folks. Okay, before we get going, I just want everyone to understand any decision that this committee reaches is only a recommendation to the council. So any recommendation to the council can, once again, if you want to, can be brought up again at council if you so wish, if you want to pull and you don't agree with the decision that was reached here today. Okay? All right. We'll start with roll call. Alderman Bill Galvin, chair, is present. Each one verbally.
Okay, Alder Barb Dorf, present.
Alder Corpus Dax, present.
Alder Kathy LaFave, present.
Okay. Good. Okay. I'm looking for approval of the agenda.
Move to approve the agenda.
Second.
Approval of the agenda by Alder Barb Dorf, seconded by Alder LaFave. All in favor?
Aye.
Any opposed? That's unanimous. Approval of the minutes from May 22nd, 2018.
I'll approve the minutes.
Second. Okay.
Okay.
Waiting.
I've got a approval by Alder LaFave and a second, I think, on the tie was Alder Corpus Dax. All in favor?
Aye.
None opposed, that's unanimous. Okay. On the regular order of business, number 2, update and discussion on bus mechanic labor negotiations. The committee may convene in closed session pursuant to state statute 19.85 sub 1 sub E Wisconsin statutes for purpose of deliberating or negotiating public employee contracts for competitive or bargaining reasons. The committee may...
Bill, you skipped the consideration on the erosion control specialist.
I don't see that.
Regular business, item 1.
Oh, it's out of order.
It's out of order. We have number 2 first.
Oh, yeah.
Oh. And then it goes 213. Okay. So number 1 is right.
Okay. All right, I'll jump down to number 1 then. Consideration with possible action on a request to fill new position of erosion control specialist in public works and subsequent vacancies. Staff?
The Public Works Department is requesting a new position of erosion control specialist, and also the ability to fill that due to some workload challenges and some issues that have been raised. And Director Vernier is here to provide additional information or answer any questions.
Steve?
Well, as Melanie indicated, prior to about 2 years ago, we didn't have any erosion control specialists as part of the table of organization. So due to response to a notice of violation that was filed against the city by the Department of Natural Resources for failure to enforce our erosion control ordinance, we brought a new position forward and staffed that with one individual. The workload that that individual is currently facing is more than what he has time for. As a result, we are getting some complaints from the contracting community, builders, and folks who are taking out permits with the city relative to our ability to respond in a timely manner. And we are physically not getting out into the field to complete the number of erosion control inspections that we need to get completed. So because we already have this position as part of the table of organization, we're simply asking to fill a second position and add that to the table of organization. This has no direct levy impact as it is funded under the stormwater utility, so the stormwater charges that go on everybody's water bill, that's how this position is paid for. It's not part of the tax levy.
Okay. Steve, how many of these violations did we have?
The violation from the DNR?
Yes.
It was a single violation, but what happens is you are in violation of your permit. What could happen is we could lose our ability to discharge stormwater to waters of the state.
Were we just not doing the work, or we were just late on it, or why did the DNR come at us?
a lot of the inspections that were required simply weren't being performed. What happened was that we had a disconnect. There was, a lot of things were falling between the cracks because we were split. We didn't have a single agency that was responsible for all of the inspections.
Okay.
If it happened within the public right-of-way, the Department of Public Works was responsible for it. If it happened on the private side of the property line, that fell to Community and Economic Development. So because of that disconnect, we didn't have a single agency that was responsible for making sure that all of these things got done. As a result of that, we wound up rewriting the ordinance, and all erosion control activities were placed under Department of Public Works so we could ensure that they were being followed through.
Okay, and so when people get a permit, if it's private company, private property, it goes to you. If it's
Yep.
public, it goes to you.
Correct.
Okay. And how much of a delay are we experiencing now with the contractors?
We try to respond in 3 weeks. On rare occasions, it goes out 4 or 5.
So that could delay a project quite a bit.
Yeah,
Because they're looking to
especially.
get a shovel in the ground.
Especially if you have a builder who's looking to get a house built and they've got a buyer or somebody they're under contract with and they want to get moving, yeah, that can cause problems.
Okay, and this money, obviously, I don't believe was budgeted for the
It was
sewer.
not, but that'll be up to us to find that in our stormwater utility budget for the year.
So you look for some money that wasn't spent or cut some stuff here and there?
Correct.
Okay, and then it'll be budgeted too?
We will make sure it's budgeted for in 2019, yes.
All right, thank you. That's all I had.
Yeah, good question.
Well, this is certainly been an issue in my district, and because we need a building to go on, and I totally have, very familiar with us getting the violation by the state and how things needed to be tightened up, and there's a lot of resentment on some part of some people because things were tightened up, because they didn't used to have to do it this way, but now they do have to do it. But we need this position, so I'm very much in favor of us doing this.
Okay.
Yes, exactly. It sounds like, yeah, definitely needed, and under one head. Yeah.
Okay. Any other questions for Steve? All right, thank you, Steve.
I'd like to move to approve.
Motion to
Second.
approve, seconded by, motion approved by Alder Dorf, seconded by Alder LaFave. All in favor?
Aye.
Any opposed? That passes unanimously.
No, you
We need to go back.
Good to go? All right, I'll start reading this whole thing over again. Update and discussion on bus mechanic labor negotiations. The committee may convene in closed session pursuant to state statute 19.85 sub 1 sub E for purposes of deliberating or negotiating public employee contracts for competitive or bargaining reasons. The committee may thereafter reconvene in open session pursuant to sub 19.85 sub 2 to report the results of the closed session and consider the balance of the agenda. Staff?
Do you have a motion to go into closed session?
Is that what you want?
Yes.
Yes.
Okay.
Motion to go into closed session.
Second?
Motion to go in closed session by Alder
Corpus
Cora
Tax.
Corpus Dax and seconded by Alder Dorf. All in favor?
Aye.
Any opposed? No. Okay, folks, we're in closed session, so I just have...
If I can't see behind that pink. Oh. That's just the thing.
How are you?
Take this down, I guess. Okay. Take that down.
Oh, yeah.
Can't see you guys.
All right, the committee is back in open session, and I would entertain
Motion for the staff to proceed as recommended.
Second.
okay, I have a motion by Alder Corpus Dax, seconded by Alder LaFave. All in favor?
Aye.
Aye.
Any opposed? That passes unanimously. All right. Number 3. Good to go? Okay. Number 3, consideration with possible action and review of standards of conduct SRO expectations grievance. The committee may convene in closed session pursuant to state statute 19.85 sub 1 sub A for the purpose of deliberating concerning a case which was the subject of any judicial or quasi-judicial trial or hearing before that governmental body. The committee may thereafter reconvene in open session pursuant to State Statute 19.85 sub 2 to report any actions taken during closed session to consider all other matters on the agenda. Staff.
You should have received a packet of information,
Mhm.
Okay.
and the Assistant City Attorney, Kristen Johnson, is here if you have any more information or have any questions.
All right, I have something to read first. It is the goal of the Personnel Committee to provide and conduct a hearing that is both fair in form, appearance, and substance. To ensure that this hearing satisfies these goals, I ask myself and each Personnel Committee member to confirm the following. Each member does not have an interest or conflict of interest in this matter.
I do not.
I do
You do
not.
not.
Do not? Okay. And I will, for the public record, say that I have worked with Tracy for a number of years. I consider her my friend, but I also feel that I can render a fair and impartial judgment in this matter. Okay. No one has received any communication about this matter. In other words, any ex parte communications other than communications regarding procedure and delivery of materials.
I have not.
Okay. The parties are entitled to a decision on the record based upon the labor agreement between the City of Green Bay and the Green Bay Professional Police Association in effect as of the date of the event complained thereof. The Personnel Committee will make findings of fact and conclusions of law based upon the record before it. At this time, the following materials have been submitted into record. Number one, the grievance identified as Green Bay Professional Police Association Contract Violation Information Form dated February 28, 2018. Number two, a letter from Captain Jeremy Morosky dated June 6, 2018, along with 8 attachments. Sub A is an investigative report, 17-37. Sub B, Liska DAP, dated 2/26 of 18. Sub C, Chief Smith's initial response, dated 3/29 of 18. Sub D, Chief Smith's initial response, dated sub 2 of 18. Sub E, Chief Smith's response to step 1, dated 4/9 of 2018. Sub F, Liska step 2 grievance, dated 4/23 of 18. Sub G, HR Director Joe Fall's review, dated 5/11 of 18. Sub H, Liska step 3 grievance, dated 5/30 of 2018. And sub I, letter from Chief Smith, dated 2/29 of 18. Sub J, GBPD policy 320, standards of conduct. And sub K, SRO expectations. Next, I will ask if either of the parties is requesting a fact-finding hearing pursuant to section 3.8.3 of the labor agreement. The committee may decide whether to hold a fact-finding hearing. Is either party requesting a hearing at this time?
SRO Liska is requesting a fact-finding hearing.
The department is not requesting a fact-finding hearing. If we are going to do a hearing, I certainly would believe that today's not the appropriate day to do that, as we want to call people in.
Okay. All right, then we have a request, and so the committee needs to make a decision. We have to vote whether we want to grant that fact-finding hearing.
Today or ever.
First, we vote whether we're going to hold one, and then we'll decide when to hold it. Okay?
Yes.
So, if a committee decides to hold a hearing, select a date for the hearing with at least a 10-day working day notice to the parties. Establish a deadline for any additional written submissions, possibly a week before the hearing. Take a motion to schedule the hearing for that date, and then take a motion to adjourn until that hearing.
So I think at this time you want to make a motion maybe to have a hearing?
Right.
If I could interject, I think the facts of this are quite clear. I think it's been fully documented. The incident involving the 2-day suspension is not the purview of this committee. It's the purview under Wisconsin Statute 6213 of the Police and Fire Commission. That has been sent to the Police and Fire Commission for a hearing, and that hearing date has passed. What that means is it is out of statute. She requested a hearing before the Police and Fire Commission and missed the statute. So she will be unable to have a hearing before the Police and Fire Commission. I would submit that you have the documentation of the incident that occurred here, or the series of incidents that occurred, and I'm ready to proceed and discuss this matter if you want to do it today.
Sure, absolutely. Absolutely, and I would prefer from now on that you approach the, just so we can get it on the recording from now on. So,
Do you want us to approach the
yes, if you
podium?
would,
Oh,
please.
And could you state your name?
Sure. I'm Attorney Kelly Windor, and I am representing the grievant, SR Liska. Basically, what the issue sort of has been, there's two separate areas of law. The 10-day timeline for SR Liska to challenge her suspension is actually a Police and Fire Commission rule. There's not anything statutorily requiring the 10 days. That's sort of outside the purview of today's hearing, which is just basically that we're asking you to have a fact-finding hearing so that we could flesh out some of the issues that she's raised in her grievance. I think the committee would benefit from some testimony from some of the people involved. And basically, I think the spirit of her grievance is that it violates the collective bargaining agreement as it relates to how disciplinary investigations are supposed to be handled. I can certainly go into that in a little bit more detail, but I would certainly also submit something in writing prior to the hearing so you can kind of see, you know, what collective bargaining agreement provisions we're alleging were violated, basically.
Okay, do you agree with the chief that her time to appeal the 2-day suspension to the Police and Fire Commission is expired, or?
Well, based on my review of the applicable case law and statutes, there's nothing in 6213 that says she has to request that within 10 days. That's just the Police and Fire Commission rule.
Okay.
It's my understanding she made a request for the just cause hearing, as it's sort of colloquially referred to as, sometime within 25 to 30 days after she was served with notice of the suspension.
Okay.
So she was served with notice of the suspension on February 28th. The Police and Fire Commission rule is she has 10 days to file an appeal with the Police and Fire Commission following the filing of the suspension or notice of the suspension. There was nothing in the letter that the chief gave her, pointing her to that Police and Fire Commission rule, and I'm not trying to testify, but based on just a Google search, I wasn't able to find that that's published anywhere. She did not have an attorney at the time who I'm not sure was aware of that. Her union somehow believed it was a 25-day rule, and they were, from sort of the timeline that I reviewed, were within the 25 days, but not necessarily the 10 days.
Okay.
Long story short, I also think she should be entitled to a just cause hearing just under due process, I guess, due process considerations. When an officer is deprived of property or liberty interest, as she was in this case, both with the administrative, well, not suspension, but the administrative leave, and then the denial of the 60 hours of flex time on top of the suspension. It's a very convoluted area of law.
So, in the end, what are you looking for this committee? What part of this discipline are you looking for us to rule on?
Basically, that the investigation did not comply with the collective bargaining agreement. There were things that were considered outside the scope of what the investigation initially started as. Sort of principles of progressive discipline. She eventually was disciplined for not showing up to school on time at 7:30. If she had been given notice of that or just been told, please show up at 7:30, she would have been. There's, as far as my review of the case, there had been no other discipline of any other school resource officers for not being at school on time.
If you're successful with this grievance, with this hearing, what do you think that will accomplish?
Well, I think it would accomplish showing that because the evidence obtained throughout the investigation was obtained in violation of the collective bargaining agreement, that the evidence that was then used against her to suspend her, to place her on administrative leave, and to sort of deny her the opportunity to earn the 60 hours of flex time shouldn't have been used, and therefore she shouldn't have been suspended or denied the opportunity to earn that flex time.
All right, thank you. Does anyone else have questions? Because we're only talking about whether we should
Right.
have a hearing.
Right.
Right. So we don't want to get into a lot of details or anything else right now. All right. Thank you. Chief?
Thank you. Andrew Smith, representing the Green Bay Police Department. Recall that the grievance you have is on your that table there is what this is about. This is not an expansion of looking into other areas. This is not something where we go and explore different areas of the department and what we did or we didn't. I believe you're here to rule on the grievance at hand that's in your hand and not all the other issues that are being brought up here. But know this is about an officer neglecting their duty. This is about an officer who knew that she was supposed to be at her school at 7:30 and time again failed to respond to that duty, failed to respond to that school on time, not because she was doing police work like some of the other officers do, but because she was out at an alley on the opposite direction from her school chit-chatting with a friend for many minutes at a time on many occasions over and over again. That's what this is about. I think it's quite clear that she didn't do what she was supposed to do. It's quite clear that those allegations are sustained. The things that she's discussing about having a development assistance plan, I think you would agree, once you look at the facts that you have presented in front of you, that a development assistance plan was in order, and that I think the rules were followed, and I think you should take a look at the grievance that she submitted, because that's why we're here. We're not here to explore other issues that are being brought up ancillary to this. This is about the grievance in your hand, not about all the other stuff that's trying to be brought into it. But whatever decision you make, I'm certainly happy to respond to it however you'd like.
Can we get a little bit on March?
Yes. Kristen?
Sure, so I think at this point, again, it's up to the committee to decide if you believe you have enough information to rule on this matter. You can do that today, and we would recommend a closed session. If you think that you need more information, we would request or recommend that you do schedule a hearing. You know, as Alderman Galvin indicated, you could also request that the parties submit a more thorough written submission to perhaps flesh out some of these issues. That could be done, you know, a week prior to the hearing that you would schedule. You could review those materials. If at that point you determine that you do have enough information to rule at that point, you could do that as well, or follow through with the hearing that you'd scheduled.
So what we're being asked to rule on is whether or not we agree that this grievance is a valid grievance and that the discipline, no, what are we being asked to rule on?
Well, not whether it's valid, but whether there's enough substance to allow them more time to present their cases and whether it's valid or not. Isn't it?
Well, right, I guess I'm sorry, right now you're ruling on whether or not you want more information.
And say we don't want more information. I mean, we maybe do, but say we don't. Then what do we rule on?
Then we would recommend you go into closed session and deliberate the grievance that was filed.
So in the end, that's what we would be
Correct.
doing. That's my question today.
Right.
Okay. All right. Wow. There's a lot of information.
There is. I have some questions.
You can go into closed session if you want to deliberate even whether or not to have a hearing. You can do that as well, or you can do that in open session. So if you want to deliberate whether or not to even hold a hearing, you can do that in closed session.
So
What's the
if you
wishes?
decide that you want to go ahead with a hearing, it has to be in the closed session?
No. If we would have a hearing, it would be at a later date, and it would be kind of like a court hearing. Each side would present its reasons as to why they feel the grievance should be sustained or why it should be denied. We could, if we feel we don't need any more information, we could go into closed session right now to deliberate. Or if we don't feel we have enough information, if there's some questions we have, then we would have the hearing.
Point of
Yes.
clarification, sir, would you be able to ask those questions today of myself or Ms. Windorf and get the answers that you need and not have to go into hearing? I'm only concerned about having to hire an attorney to come up here and sit through hearing and charge the city for what I think is an awful lot of money for something that I think you have right in front of you.
You can certainly ask questions today if you want. If you want to proceed with just the information that you have in front of you, you can. They can do oral arguments basically in support of what they've submitted to the committee already. So if that's again, if you believe that you have enough information in the written submissions that were already given to you, which would be the grievance that was filed by Officer Liska and then the letter from Captain Moraski and all the attachments, you can review those and then ask both Attorney Windorf and the chief questions about what they filed for clarification purposes.
Do you ladies have questions?
I'd like to know what the union
Well, with,
is.
just, do you have questions that the paperwork you have does not answer for you?
Yeah, I think I have questions.
Okay. Barb?
I don't know that I have questions that the paperwork doesn't answer for me. It's fairly comprehensive.
Veronica?
No. I don't have questions.
Okay.
Do you?
I have a few, but I think it also could be answered here. Are both sides though prepared to get into some of the meat of this matter?
Yes.
Absolutely.
All right. Then I would say that we do it.
You should do it.
Right.
That's what I'm looking
Okay.
Can you just check?
I would ask Kristen, close her open session.
For the sake of everyone.
All these questions I would recommend being done in open session.
Open session, okay.
I mean, everything that was filed,
Okay.
was.
And do we ask either of the parties if they have any preference on this? I mean, is that okay to ask? I mean, if they would prefer to be closed or stay open, or it really does, it's not up to them, it's up to us?
No, I would keep it open.
Okay. All right. It was just a second to get our stuff out. Okay, if we are not going to have a hearing, ask parties whether they would like to make arguments in support of the written submissions.
Yes, please.
Okay. I'm sorry, could I get your name again?
Carly Windorf.
Sorry.
C-A-R-L-E-Y.
Okay.
Last name Windorf, W-I-N-D-O-R-F-F.
Okay. Okay, so who goes first?
Keep reading.
All right. The parties wish to make arguments to ensure that this hearing proceeds in an orderly fashion. I will describe the process that we follow. Grievant will have 10 minutes to present its argument in support of the written submissions. The city will have 10 minutes to present its argument in support of written submissions. Grievant will then have 5 minutes for closing. The city will have 5 minutes for closing. Throughout this process, Personnel Committee members and chair may ask questions of any speaker. Please answer the questions asked and do not engage in debate. The committee will close the hearing and enter in committee deliberations. I would imagine if we're asking questions, that's not going to impact their 10
Right.
minutes. Okay. So it's going to be kind of a loose 10 minutes. All right. If anyone needs accommodation to hear or speak, please advise me now. Assistance will be provided if necessary. And if you're ready, Ms. Windorf.
Thank you. And perhaps I should have started out with this, with my request for the fact-finding hearing. But basically, for the following reasons, I think it would be helpful for the committee to have the hearing, but I will continue with my argument. So basically, this all started sometime in September of last year. Lieutenant Brester told SRO Liska that there were rumors going around that she was having an affair with another officer while on duty. She denied that was happening to Lieutenant Brester. She basically was then, well, there is a internal investigation 17-000037 initiated. That's dated November 30th of 2017, which if I was not able to review Jeremy Moreski's filings, but if the committee needs that, I do have a copy of that. It's not so much the content. Well, we're disputing the content, and we're also just pointing out that the data is significant because the internal investigation into that started in November of 2017, It's pertinent to the collective bargaining agreement in that the collective bargaining agreement in section 25.3.1 indicates that the subject matter of any investigation shall be confined solely to those areas that are being investigated. Basically, the investigation took a different turn. They found, as far as I could tell, no basis for the having sex with this officer on duty. However, it is the same officer that she's alleged to have met with for inappropriate durations, even though she's given the department a number of reasons, work-related reasons why she was having conversations with that officer. Part of that is because they were both part of the police officer support team, otherwise known as POST, which basically assists officers in the department with mental health issues that are unique to law enforcement. A lot of those matters are incredibly confidential. Then in January of 2018, SRO Liska was informed that she'd be placed on paid administrative leave and would not be eligible to accumulate and earn SRO flex time, which I believe accumulated during the time she was off for about 60 hours. She suffered some significant, and obviously you can see that she's continuing to have a very emotional response to this. This is a very stressful environment. It was incredibly embarrassing to her to have to deal with this, both with people she worked with at the school. She was not allowed to comment on the investigation. And meanwhile, a lot of rumors, she wasn't basically able to respond to any rumors that she was having an affair while on duty. Her reputation was incredibly tarnished by this. As the committee may or may not be aware, in 2013, she was involved in a very significant car accident. She was hit by, I believe, a drunk driver while on duty. It has pretty significant health needs and continuing back issues. During her administrative suspension, she was placed in an administrative duty. She was working in the fingerprint room in sedentary work for those 7 weeks.
Excuse me. So she was placed on administrative leave.
Administrative duty.
Duty.
I'm sorry, yes.
Administrative duty, which was working at the PD, inside the PD, but then she had another issue that came up? Is that what you're saying?
Yes.
Okay. During that time period?
Well, she didn't have another issue that came up, but the sedentary work impacted her ability to continue doing the sedentary work.
Okay.
We
So she had a medical condition?
Right.
And what was the result of that?
She called in sick several days, and it sort of served to only enrage Lieutenant Brester, who had been supervising her during this time. Apparently this duty was videotaped, although we haven't obtained the videotape yet, and the only reason she knows that was because Lieutenant Brester told her it was videotaped, and then she basically was isolated from the rest of the department, it sounds like, for this entire duration. And then he would make comments to her like she was wearing the wrong thing. SROs on Fridays are allowed to wear like school spirit colors, and I don't think she was told anything as far as what she could wear while on administrative duty. I don't think she had contact with him that day, and he came in later and said, I was watching the video, you're wearing the wrong thing. So just kind of a strange thing that you need to be videotaping an employee, along with the back issues that she was in such pain that at points she was like lying on the floor and crying, and she, like I said, just sustained just an incredible amount of emotional distress as a result of the administrative duty, which again lends itself to, if they had just told her that the issue was arriving to work at 7:30, she would have happily corrected that mistake. I think even up to this point, the denial of the ability to earn the 60 hours and then being placed on administrative duty is already an exaggerated response to something that could have been corrected with a minimal amount of discipline.
So she's on administrative duty, all of this is happening, and she has no idea it's because she wasn't reporting to work on time?
Right, because she was originally told that it was because they were investigating whether she was having sex on duty.
Wait, sex on duty or just having an affair?
Sounds mixed. Both.
I'm both.
Both.
And was she given any paperwork to this effect? I mean, when she was brought in initially and then placed on?
I have a letter with the administrative duty and then I believe 7 alleged violations. She was given an investigation and a Loudermill hearing related to those. There's some issues as to when she received her Loudermill letter that is designed to basically inform her of the who, what, where, and when, and why of the alleged violations. The letter that I have is dated, the letter that I have is dated sometime in February, but she did not see it until April 19th. So she was never really given the opportunity to respond to the facts that Chief Smith had considered and was using to sustain the policy violations. And also, she was never really given the opportunity outside of the Loudermill hearing, which we also have not been able to yet review because I believe that those are also recorded. She was not able to respond to the level of discipline she thought was appropriate. She had as the chief had indicated, she was placed in the development assistance plan. She was returned to the school district March 12th of 2018. She had requested early March 5th, 2018, information on other officers' scan times or check-in times just to see if other SROs were also checking in at 7:30, and if they weren't, that goes to the 7 test of just cause as to whether this policy is being enforced in a fair and impartial manner. That request, the school district referred her to her commander, who said that the department did not retain that information.
But just, wait. I thought you said in April, it wasn't until April she found out that it was because she was late, but this was in March that we're asking about it, that the policy's being enforced. So why would she ask that in March?
So January, she was given the formal complaint against personnel that lists the 7 policy violations. That was basically her first notice of what she was being investigated for, secondary to this November investigation, and that's where I think a fact-finding hearing would help the committee sort of figure out what had happened and at what point in time. But certainly by January, it had changed from the having steps on duty to the breaks and the school resource officer expectations.
So by January, it was for the excessive breaks and coming to work late?
It wasn't coming to work late, it was violating the school resource officer expectations, which aren't contained within the Green Bay Police Department policy. And also, it's our assertion that it's not enforced in any consistent manner, that a school resource officer would have noticed that if they didn't show up to their school at 7:30 on the dot, that they would be subject to any suspension or denial of opportunity to earn flex time. So the policy violations are based on the alleged violation of the school resource officer expectations, if that makes sense.
I'm fairly familiar with police school resource officer expectations, having been in charge of that
Oh.
program for 12 years.
Oh, okay.
I'm very familiar with what I expected from my school resource
Sure.
officers, which we could talk about that later.
Sure. And again, it wasn't that the conversations were not work-related. Of course, I don't know that she can say what every content of every conversation was, but we were both in the post team together. And I don't think that there had been any complaints that she was aware of from her school as far as her showing up late or after a incredibly tardy time. And I would also note that there was no evidence that we're aware of that indicated that she had been having sex on duty.
But that's not what this is about.
Right.
Is it possible that an investigation that starts looking at one thing could morph into another thing if evidence becomes apparent during that investigation?
Well, and that's where I'm looking at the collective bargaining agreement, Article 25, subsection 3.1. I mean, I guess if they have grounds for reasonable suspicion that the officer may be subject to disciplinary action, but when you're running it through the Southern Test of Just Cause, she's never been disciplined before in her 16 years of employment with the department. Nobody else has been subject to discipline for the same offense as far as the grievant is aware.
Basically, she's being charged with not showing up at her duty station on time, is that?
Right.
And no one else in this department history has ever been disciplined for not being at their duty station on time?
I can't say that for sure.
Or are you just talking about SROs?
School resource officers.
Okay. But as far as police officers go?
Right. Oh, no, I just mean school resource
Okay.
officers.
But school resource officers being paid by the school district to be in schools wouldn't have any idea that we'd want them in the school when the school day begins? They just,
And
wouldn't even know that?
I completely agree with you. I'm not saying that she showed up at like 8:30 every day. It's just a thing of, she requested the scan times of when other officers were logging in and was denied that, so really we have no way to know whether this is being enforced consistently or not.
So then it comes down to whether it's being enforced. I mean, the expectation, I know, for at least
Right.
12 years has been that you're in your schools. You go to roll call, or you don't even go to roll call, you get to your schools. If
Right.
there are incidents going on,
Right.
you get to your schools. So
Right.
I have a day-to-day awareness of that. And
Absolutely.
certainly there has been discipline for people that were not showing up when I was in charge of that program. So, so I just, it would be hard to believe that someone wouldn't realize that they would need to be at work at 7:30.
And we're not saying that that's like an unreasonable expectation. It's just when you're looking at what happened, you started an internal investigation instead of just simply having an oral conversation and saying, we have a problem with how quickly you're getting to your school. Can you please correct it? I mean, there was no opportunity to correct the mistake whatsoever. She was basically just spied on for how long, and then
I did have
suspended.
questions about why was it I think it was 8 times that it happened before she was even asked about it. I mean, I did question that as to why it wouldn't have been addressed immediately, you know, that you'd have to get there. So I'm sure we'll hear those answers when the other side gets their turn to talk. But, okay. So we're not even, so the issue isn't really whether she was there or not. It's that what we're hanging our hat on here is that if everybody isn't consistently treated the same way within this group of people, that she's being treated unfairly because everybody isn't being treated
right.
and
And she
asked.
was sort of denied the opportunity to discover whether other officers weren't logging into their school on time, which is why I mentioned the officer scan times and.
Well, if I could ask,
Yeah.
if we're all adults, police officers, by definition, have kind of an independent job. We trust them to go out and do their job. We don't have someone sitting in the seat next to them making sure they're doing their job. We do have some ways of checking, but it's very loose and it's not very defined because we trust that they're doing their job. So if we're trusting they're all out doing their job, we assume they're doing their job, but we have evidence that suddenly they're not, is that wrong then for the department to investigate that? Or are they then suddenly supposed to investigate every SRO to make sure they're all doing their job?
Well, I think at the outset, if you're investigating whether she's having sex on duty and then you come to realize that she maybe isn't, but then you have a problem with her response time to her school, then like you said, we're all adults, just simply give her the opportunity to correct her mistakes. And if the expectation or the you know, there's the written expectations and the expectations of everybody involved in the SRO program, and then there's what actually happens. And I think the officer scan times would have been helpful to the committee to see if everybody's arriving at school at 7:30, or if other officers are talking to other officers on their way from roll call to their schools.
If all the officers, say we found out none of the SROs are reporting to school by 7:30, all in violation of the agreement with the schools and by what I'm being told here, some job thing that was put together. They're all in violation. Does that mean they all get a pass? Or does that mean we say, geez, this is not right, this is wrong?
I think under the 7 tests of just cause, you look at their disciplinary records, relatively clean disciplinary records, especially those that are 10 years free of discipline or more, are generally looked on with favor and are a huge mitigating factor. And I also think with respect to principles of progressive discipline, I think, especially in this case, if you're a new chief and you want to enforce expectations and policies in ways that are different than previous chiefs, then you give everybody the opportunity to correct their mistakes, but also.
Would you say that, based on what you've read in the paper about our current chief, do you think there's been a strong message sent to everybody already that their expectations are, if not stronger, going to be much more severe than they have been in the past?
Absolutely, but I just think with respect to the school resource officers, and again, that's part of the reason why we requested the fact-finding hearing, just to flesh out some of the other school resource officers who are currently at other schools, and just to hear some of the testimony related to that.
So looking at those 7 tests of just cause, is it a reasonable rule that the person get to work on time at the school? I would say, yeah, passes 1. 2, notice, did the employee receive adequate notice of the work rule? School starts at 7:30. SROs are hired by the school district. I don't know how a person could think that's not. Let's see, sufficient investigation. See, if they would have talked to her after the first time she was late to work, I think I would have felt like that was being picked on, though. I mean, I'm late once and I'm already being called in. But 8 times it seems excessive too. So I'm just trying to look at it. But I wouldn't think you'd do it. Was it a fair investigation? Is there proof of misconduct? Is there equal treatment? That's what we're looking at, number 6, right?
Yeah.
Have you dealt with your employees equally without discrimination? Are work rules applied consistently? Wow. And I guess I would, based on, and Grant, we're going to listen to the chief, but based on what you're saying, were they applied fairly? Well, it sounds like she was the first one discovered not reporting to school on time. So if you're going to treat her fairly, you treat her what? How you treat all other officers?
Right.
And how are other officers treated who don't report to their duty station on time?
Well, I think they didn't look into that because they deemed the officer scan times of when they arrived at their schools not pertinent to this investigation.
They have to scan in when they go to their schools.
ID badge or something?
You mean like when you open the door? But everybody doesn't necessarily. I mean, the doors are unlocked before 7, 5:30. What?
I was scanning.
You did. Okay, I'm not. I mean, the doors are not locked until after all the students are in. You can just go in the front door without scanning in. Officers could have done that. You did. But it may not be an expectation that everyone scans in. There may not even be that record available. And I'm not even sure how we get that, thinking of how the school district runs. So I don't even know if it's something that's even possible to get.
I guess my point is, I just think it should have been handled differently. I think she should have been given an opportunity to correct her mistake, maybe not after the first time, but certainly before the 8th time, and especially when considering this started out as whether she was having sex on duty and morphed into something else is concerning, and then especially given her lack of discipline for the last 16 years, I think those were significant mitigating factors, especially when contrasted with her 7 weeks of administrative duty, which had a pretty significant toll on her physical and mental health and well-being. And then a lot of the treatment from her lieutenant, who, it's my understanding, and I don't necessarily know how this is all supposed to work because I didn't review the Green Bay Police Department policies on this, but her lieutenant at several points throughout this entire timeline had, and again, this is why I was requesting the fact-finding hearing, because I had anticipated having these witnesses for the committee. The lieutenant who had conducted the initial investigation, there are several witnesses that indicate that he called SRO Liska a cunt and a bitch on several occasions. So the idea that the investigation wasn't conducted in a fair manner, it was conducted by Lieutenant Brester, who I would anticipate there would be a testimony from SRO Liska and some of the other officers who heard these comments, that his behavior with her was pretty inappropriate.
He called her that to her face or in private conversations outside of her hearing?
Private conversations outside of her hearing.
And did these people report this to a supervisor or HR?
It is my understanding that one of the witnesses reported it to the department and an investigation is ongoing.
Okay, so you are also alleging that this investigation could be flawed because of his attitude towards her?
Right.
Yet there's a lot of evidence in here that other people observed this. Other, Commander Rungy was one, I think.
Commander Abel,
yeah.
Lieutenant Allen, and it sounds like she self-admitted during the interview that she wasn't reporting to school on time.
And she'll be the first one to tell you that
Right.
she wasn't.
And for whatever reason it was, I mean, whether it be for posts or just what did you do this weekend, she's not at school. And as I understand it, the school pays her salary, they have expectations for these officers to be at school. Whether there's someone following her around to make sure they're complying with that or not, I think is neither here nor there. There is that expectation.
Absolutely.
Is there anything else you'd like to present at this time?
Do you want me to submit any corroborating documentation of all of the things that I've brought up?
Is it beyond what we have in these 60 pages of stuff?
Yeah.
What kind of?
Can you just, if you listed what you have,
Sure. Here it is. The ones that I read off, investigative report 17-37.
and that's dated November 30th?
I do not have a date on this one.
Yes, it is, November
Okay.
30th. Okay, thank you.
Then Liska DAP dated 2/26/18.
Okay,
Chief Smith's response 3/29/18.
okay.
Initial response of Chief Smith 4/2/18.
Okay,
Chief Smith's response to step 1 4/9/18. Liska step 2 grievance. Oh, I'm sorry. Do you have that last one? That would be
Yes.
Chief Smith's response 4/9/18.
yes,
Okay. Liska step 2 grievance 4/23/18.
yes,
Director Falls review 5/11/18.
yes,
Liska step 3 grievance 5/30/18.
yes,
Letter from Chief Smith 2/29/18. Okay. GBPD policy 320 standards of conduct.
yes,
Okay. And then lastly, SRO expectations. There's no date on that.
yes.
Okay. And you have other documentation for us?
Yes, I have her performance statistics that shows she's the highest performing school resource officer. If you're looking at traffic citations, municipal citations, written warnings, criminal arrests, CAD dispatch calls, self-initiated calls. I also have the January 18th, 2018 letter indicating she will be placed on administrative duty, as well as the initial 7 alleged policy violations, and then the corroborating initial 7 policy violations from the Green Bay Police Department policy. And then her request for the officer scan times, and then a letter dated February 13th of 2018 related to the Loudermill hearing, which again she
indicates to me that she did not see until April 19th. And if you'd like, I can certainly follow up via email those documents too. I can make copies if you guys want.
Sure. You want to break or you want to?
I think you should probably.
Okay. All right. Then Chief Smith, are you ready?
Sure.
All right.
First of all, I'd like to clear up some facts that have been misrepresented here, and I think it's really important. This is a very simple case of an officer not doing their job when they have clearly been given the expectations, been spoken to about their job, and failed to respond to that informal discussion. This was never about sex on duty. There's no allegations of sex on duty. There was a rumor around the department that even I heard that these two were romantically involved. And perhaps Jeff Brester mentioned sex on duty in the casual conversation he had at the subway in August with Officer Liska, but this was not about sex on duty. No one was accused of sex on duty, nothing to do with sex on duty. In August of this past summer, Lieutenant Brester observed Detective Liska, or correction, Officer Liska and Officer Eklund in the subway. He recalled that there had been rumors around the department about them two spending an inordinate amount of time together while they're on duty. Also included in there was an allegation by someone made that they may be having sex on duty. He pulled her aside at the subway in August of 2017 and said, Officer Liska, just so you know, these rumors are out there, and you shouldn't be spending so much time with Officer Eklund while you're on duty. Warning number one. On August 28th, Officer Liska met formally with Commander Runge and Lieutenant Brester in Commander Runge's office.
Well, I'm sorry, what was the date?
The date was August 28th, to the best of my knowledge. They met together and they talked about exactly the same thing, spending time together. They reviewed the expectations, and I direct your attention to page 5 of the investigation, which has the school resource officer expectations, to which Officer Liska was given and acknowledged that she knew about. And I direct your attention to the first bullet point, which says, respond to school as soon as roll call is over. Be at school by 7:30 a.m. Now this, you recall, was created by school resource officers. This is not an Andrew Smith thing. This has been in place for a long time, and these were clarified and reviewed by school resource officers recently as the best practice and what the expectations are. The next line says, most high schools and middle schools start at 7:30 a.m. That includes West High School, where she was assigned, 7:30 a.m. It is important for the SROs to arrive by 7:30 to assist staff with any issues. Quite clear. She was given these when she was given the school resource assignment on January 2nd, 2017. She was assigned to the West Quadrant, which includes West High School, which starts at 7:30. The expectation is that she's there at 7:30. She was reminded that she's spending too much time with Officer Eklund. She was reminded of the expectations by Lieutenant Runge by Commander Runge and Lieutenant Eklund on August 28th. It's all in the investigation. Feel free to read.
You mean, no, you just said Lieutenant Eklund.
I'm sorry, I meant Lieutenant Brester, my bad.
Okay.
Commander Runge, Lieutenant Brester, August 28th. That's the informal meeting where they sit down and they tell her what the expectations are, remind her that she's supposed to be at the school at that time, and remind her that these rumors are out there that she's spending too much time on duty with Dave Eklund.
Okay.
Fast forward to November 30th. On November 30th, they were observed parked car to car in an alley, a gravel alley near an abandoned warehouse south of Adams in the opposite direction of the school where she's supposed to be. After roll call, Lieutenant observed her parked down there and him mentioned it to Lieutenant Brester. Lieutenant Brester took that information and then, that same day, was reminded by Captain Warwick that he had seen them parked there several times as well, parked squad to squad, knowing that she's an SRO and supposed to be at the school and not where she's supposed to be at the time she's supposed to be there. Based on those incidents, the lieutenant that notified Lieutenant Brester, and based on the information from Captain Warwick, we elected to put a GPS device on our police car that is assigned to her. The reason why we did that is because we can't afford to have somebody following her around all day to see where she's going and to see who she's hanging out with and see whether she's shirking her duties and not where she's supposed to be. So it was an easy way for us to accomplish the investigation and find out if she's where she's supposed to be or she's not. Well, after about a month, we pulled the GPS device off and found that, in fact, she was not where she's supposed to be. Time after time after time after time, she left the police station, drove in the opposite direction of the school she's supposed to be at, pulled into an alley in an area where there's no crime problem, no crime concerns, no crime considerations, and met squad to squad with Officer Eklund. How long? I don't know, by their estimate, by her estimate, it was 20 to 30 minutes. By his estimate, 30 to 45 minutes. We've got documentation all the way up into excess of 30 minutes that they were parked squad to squad there. Now, this is after 7:30, while she's supposed to be at the school. After 8 incidents of this happening, I said, enough is enough. Pull her aside, and let's end this investigation now. While we conduct the investigation, we put her on administrative duties. Now, you'll know that that is a typical thing that the police department does. If you're engaging in serious misconduct, which I consider this to be, and you're shirking your duties and you're not where you're supposed to be, and you're letting the school children down who get paid by the school, we get paid to protect those kids, and we're not there, we're not protecting those kids. As evidence of how lax this was, there was an incident that occurred where a radio call came out at one of her assigned schools, and she failed to respond to that. That was January 3rd. It's in the investigation. A disturbance occurred at one of her schools, Lincoln Elementary, 7:39 a.m. At that time, she's parked squad to squad. At that time, she's supposed to be at her school. She does not hear the call. She does not respond to the call, and other officers handle the call.
Oh, if I can interrupt. What if she had been at West High School? Would she normally have responded to Lincoln, or you're just saying because she was not where she was supposed to be, there was no chance she could respond?
If she was at West High School doing school duties, I don't have a problem with her not responding to that. But if she's chit-chatting with a friend, car to car, when she's supposed to be doing work-related duties, I do have a problem with that. And I think we need to hold our personnel accountable for what they're doing while they're being paid by the city or school district to do that job. If she had been involved in getting late to the school because she was filing reports or making copies or meeting with her lieutenant or commander or even another officer about school-related, work-related, business-related issues, we wouldn't be having this conversation. We wouldn't be here. She wouldn't have a 2-day suspension. But it wasn't. It was personal business. It was not post-related. Ben can testify as to what the post protocol are. There's no indication that there was anything to do with post issues that they were talking, both on the posting. That didn't even come up in her interview until afterward when they realized it. So the reason why we let it go 8 days is because we wanted to make sure we had a good idea of what was going on.
Well, you let it go 8 days, or you let it go a month and then check
We
to
let it
see
go,
how many times?
yeah, but virtually every day that they were both working and he wasn't assigned a call, they were meeting car to car before school.
But
every day they
If
were.
you were checking that GPS every day, would you have allowed it to go 8 days?
Well, I think we wanted to see what the scope of the problem was. You know, we know she'd already been spoken to informally by the commander and the lieutenant about her attendance and about her meeting with him back in September. So we knew she'd already.
We can test that detail. She contends that the specific attendance issue was not brought up in that meeting.
I think you'll find the investigation is pretty comprehensive about what was covered and all that business. A couple other things that need to be clarified. She was assigned to an administrative assignment, which is what we do. I've got people on administrative assignments right now and administrative schedules because of misconduct and because we're investigating misconduct on them. That's a standard practice that goes back in the department's history.
Is this normal though for 7 weeks for something like this?
I've got someone who's been on administrative assignment for many months now.
Well, that one sounds like a more complicated case. This sounds like one where we've got 8 violations. You interviewed her, you interviewed him. What went on for that 7 weeks that took so long?
Well, we've got a lot of other investigations going on. As you're aware, we've got the Sporl case, which we were working, my internal affairs guys were working on. We've got a serious case involving another detective that's in the detective squad room. We've got the case that, we've got 3 or 4 other cases that are pending and a lot of other things that are happening behind the scenes on other cases. So we couldn't just drop everything and get to this investigation. I wish we could have got this investigation done quicker, but to be honest, 7 weeks for a serious investigation like this is pretty darn quick based on our track record. There's a question about, and it's not an agreement, so it's really not something we should be considering, but there's a question about Lieutenant Brester getting a personnel complaint. He is the subject of a personnel complaint right now. After this investigation was completed, he was alleged to have made improper remarks in a private conversation. That is under investigation right now and has not yet been adjudicated. But in these interviews, not only was she represented by an attorney, but we had another officer in these interviews with her and with Officer Eklund, so it wasn't just a one-on-one interview. And certainly the information that was gleaned from these interviews, videotape recorded and audio taped, I have no question about the accuracy of these interviews and the accuracy of what was transposed there. You are correct. Most officers don't scan their way into the school. When the doors are open, there's no reason to pull out your card and scan. If the door's open, everybody walks in, students and officers included. It's quite clear to me that this is a simple case. This is a simple case of being where you're supposed to be while you're paid to be there or not. And my real concern about this is during those times when she's 1.5 miles or 2 miles away from the school in the opposite direction, chit-chatting with a friend, our schools were in session, doors were open, and our children were vulnerable because she was not there. And she was supposed to be there. She knew she was supposed to be there. She was told she was supposed to be there. We have the documentation that she was given that says you're supposed to be there, and she had no reason to be there that's work-related except to chit-chat with a friend in an alley where there's no other crime taking place.
What about her record?
Well, that's why she got 2 days. This was certainly much more serious. Shirking your duties like this and leaving our school exposed and our children exposed like that, that's much more than a 2-day suspension. That's much more than a 2-day suspension. The reason why it was only a 2-day suspension was because of her record. She's got a great record. You know, she had provided documentation to me about how much work she does at the school, and that's great. But had she had not a good record, this would be much more than a 2-day suspension. So to clarify, it wasn't about sex on duty. It was about not being where you're supposed to be and not having a police-related reason to be there.
I also failed to give the committee the post-team policy. I'm not sure how the department can be certain that the content of the conversations, unless they were somehow recorded. And again, I guess I just asked the committee to reconsider granting us a hearing so some of the facts could be fleshed out. It's easy for the chief and I to sit here and tell you what we think the facts are, but it's certainly a lot more helpful to a fact finder such as yourself to hear from the actual parties involved. But of course, I would defer to your decision as far as if you think you have enough to decide today.
Okay, pause. Can we revisit having a hearing?
You can.
Does anyone feel so inclined to revisit that thought? No?
She is.
Veronica?
I'll say that I am.
I'm sorry?
I'll say that I am.
Kathy?
No.
We have a time. I'm not inclined.
We don't have a tie, motion fails.
Motion fails right on a tie. Okay. Then we continue. I'm sorry. So now they each get 5 minutes of rebuttal.
Right, if they want to add anything else, they can do that. It really should just be on what was submitted to the record. No testimony should be given, and anything that wasn't submitted shouldn't be really discussed or considered.
Do you want to take a few minutes?
Yes, thank you.
Okay. Can we take a little break?
Sure.
All right, we're gonna take a break, 5 minutes or so. Okay, let's till say quarter after. So if anyone has to use the restroom or you guys want to meet somewhere else off to the side, either party, there's certainly room to do that. Committee is back in session. All right, and we were with.
I think we left off, the chief had finished.
And Carly, we're going to give you 5 minutes to finish up.
Thank you. I know I've given the committee a lot to think about today, and we are here before you on SRO Liska's grievance of the fact that she was placed on the 7 weeks of administrative duty and denied the opportunity to earn the 60 hours of flex time. With respect to the fact that the investigation started November 30th, and then she was placed on administrative leave January of 2018, and the chief has informed the court or the committee today that basically there was really not a whole lot going on in those 7 weeks is concerning. It's my understanding that the 8 violations that the department cited as the concerning behavior happened before that January of 2018. So basically it just seems that
those 7 weeks were just them processing it and figuring out the level of discipline. I think when you're considering all of the facts in this case, that the 7 weeks of the administrative duty, especially given the sedentary nature of it, coupled with her specific physical needs, the fact that she was recorded and constantly had the lieutenant commenting on her behavior and attire in that room, especially in light of his specific comments directed towards her as unreasonable. We're asking that the committee find that it was an unreasonable work rule as it relates to the collective bargaining agreement, and that you grant our grievance. Thank you.
What exactly was an unreasonable work rule? What was the work?
That she was placed on the administrative duties and denied the opportunity to earn the flex time. And that's another thing of just the consistent enforcement of it. For example, Lieutenant Brester, in that pending investigation, it's my understanding he hasn't been placed on administrative leave. So it just seems that given her work record, the mitigating factors, the 7 tests of just cause, that a more minimal level of response or discipline would have been adequate to correct the policy violations.
I know very well what flex time is, and as I'm sure it does Alder Galvin, but I don't know that the other 2 alders have any idea what 60-hour, how you earn 60 hours of flex time and why SROs want that. So could someone explain that to them, please?
And this is Detective Phil Scanlon. He's representative of the union.
Good afternoon. I'm a representative with the Green Bay Professional Police Association, and I know we've heard a lot today from different angles of the investigation. The grievance at hand is that the placement of her on administrative duty was in a unreasonable work rule, that at that time, on the 18th of January, she had already been brought in and questioned. They had the offenses that she committed, that she had answered the questions, and she had admitted to the offenses that they had alleged, and that being placed on administrative duty for 7 weeks cost her a loss of time in regards to flex time. Flex time is a Friday. The police school resource officers on administrative, or everyone in this department that's on administrative schedule has every other Friday off. Police school resource officers work Monday through Friday. So as a way to accommodate for that difference in schedule, every other Friday they gain 8 hours of pay. Then the school resource officers traditionally have off during the summer, so they accumulate that time and then use it off for the summer to be off when the kids are off. And then during the school year, they're there Monday through Friday. So that accumulated time makes up for the difference of not having off every other Friday and gives them off during the summer so they can be synced with the school district hours. So I just wanted to say briefly that we've heard a lot from both sides. The grievance here at hand in regards to that was brought forth by the Green Bay Professional Police Association is that because the investigation was, for the most part, to my knowledge, documented as far as what she had, the policy violations that she had committed, that she was put on administrative duty for 7 weeks, having a loss of that time, loss of the opportunity to build those flex days, and the remedy for that would be to compensate her for the flex time that she had lost, or give her the opportunity to accrue the time that she would have been able to accrue working at basketball games and events that school resource officers can accrue.
Real quick question. Phil, has any other officer ever been suspended pending an investigation?
Suspended or put on administrative duty?
I'm sorry, administrative leave.
Yes, administrative duty, yes.
Administrative duty.
Yes.
Have they ever missed overtime or anything else
Yes.
during that time? And how was that resolved?
I guess I can't speak for every single investigation.
To your knowledge?
To my knowledge, I'm not aware of SROs being put on administrative duty and not accruing time. I'm not aware of also any grievance regarding administrative duty where someone accrued that time back.
Okay, wait a second.
I guess you're asking me what had happened in the past?
No. Has an officer ever been put on an administrative duty?
Yes.
Have they ever missed overtime during that administrative duty time?
Yes.
And when everything was resolved, did they get that overtime back?
I do not know.
Okay. Has there ever been an SRO that's been put on administrative duty? To your knowledge?
Besides our solicitor, I'm not aware personally.
Okay, thank you.
But part of the flex time was about events that weren't worked. It's not just about this every other Friday, right? Isn't part of the flex time about that we ask them to work in the school district. They work basketball, and they accrue hours for that. They work the football games, they work the prom, whatever. If they aren't working those hours, they don't get that flex time. And by not being there for 7 weeks, she was not allowed to work those hours.
Correct.
So it's beyond just missing the opportunity to have Friday off, right?
It's both.
It's both combined, came up to 60 hours.
Any other questions before we go to Chief Smith? All right, Chief Smith?
Thank you. Just for clarification, regarding the administrative duty loss of flex time business, January 18th, 2018, she was assigned to an administrative duty while we conducted this investigation. She was placed off work by her physician on February 20th. So that was, 2 weeks later? She would have missed 2 Fridays of flex time had she been working. After that, she was on light duty and would not be able to work in the field and would not be able to work those flex days because she was on a light duty assignment and was unable to work those. I had my staff go back and check how much overtime she earned from September until the time she was placed off duty, working events at night, except for the homecoming, less than 3 hours of overtime during that time period.
Or do you mean admin time, or?
No, not flex time. This is overtime,
Okay.
working events out in the field. Less than 3 hours except for the homecoming business, which they all earn, is what I was informed of this afternoon. Just to be clear, putting someone on administrative assignment is standard practice. It's in the letter that I give and that has been given out since long before me, that you can't go out and earn overtime while you're on administrative assignment. People are placed on administrative assignments when it's serious misconduct. There were a lot involved in this investigation. We didn't just pull her in and say, did you do this? And did he do this? And you're done. We went and conducted investigations into the GPS. We looked at where they were and where they were at what time. We looked at what was going on in that particular case involving the school call that came out on Lincoln Elementary on January 3rd. We went and interviewed school administrative officials to find out if she was where she was supposed to be. And that's all in the investigation that you can see here. This is a substantial investigation, I think a very thorough investigation, which you have and you can use to judge whether we did a good job and whether the 7 weeks of time were well spent. But it was not just a one and done interview and then make her go do administrative assignments. There's some misinformation about the videotaping. That room is videotaped for the protection of our officers. It's not audio tape, but it's videotape. Has been as far as I know. We assign officers down there. In fact, I just had an officer who was light duty with a back injury working in that very desk, in that very position, doing that very thing that she was doing while she was on this administrative assignment. And he was being recorded the entire time, just like everybody is, because it's a videotape system we have for our officers' protection. That's in the fingerprint room downstairs, where we have people come in and out of this fingerprint room who are...
So it runs continuously?
Correct.
Doesn't matter if anyone's in there or not?
Correct.
Okay.
It wasn't meant to spy on anybody. It's a videotape that is on all the time.
Was it accessed during this investigation?
I believe the lieutenant checked to make sure that she was at her assigned duty, doing her assigned duties.
So he would look at the video to make sure she
would
was...
have the opportunity to do that. Yes, sir. A couple things. There's been some information about this being a post-conversation that they had down there. Neither party gave that information to the investigators when they were first questioned about what was going on, what you were talking about.
What is a post-conversation?
Peace Officer Support Team.
Oh.
So they are members of the Peace
Okay,
Officer Support
got it.
Team.
I understand.
If they are involved in a discussion involving the Peace Officer Support Team, there's a post-data form that's supposed to be completed. Standard form, completed when you have one of these conversations. Obviously, 0 of them were completed during this time. So if they were having this post-conference or post-interview, they didn't tell us about it when they were interviewed, and they didn't do the protocol and follow the post policy as they were supposed to. So that's something that came up after the investigation was just about over. A couple things I want to make clear. One thing that is kind of disturbing, it's a simple case. It's about holding people accountable for being where they're supposed to be, where we're paying them to be, where they need to be to protect our kids, and where they weren't. Had they been doing real police work, had they been doing something that was police-related, something that was important that needed to be done, we wouldn't be here today, as I mentioned. If you look at the total times, I have 189 minutes over the month that we looked at them, that they were chit-chatting down there. 189 minutes, about 3 hours. If you extrapolate that back to the time she started, which they both said that they had been engaging in this activity from the time when she started basically her slow positions. That's close to 24 hours of chit-chatting in an alley, away from your assignment, for no reason. The facts are clear, the case is simple, you have all the information in front of you, they did a thorough, fair investigation, it meets all 7 steps of just cause. What we're trying to do here is send a message to all of our officers. Do your job, or there'll be consequences. And that's why we're here, and I think it's quite clear that the job wasn't being done for the kids at that time.
I just have one clarification on the light duty, that she would have been entitled to less time. She wouldn't have had to placed on light duty had she not been placed on the administrative duty. Essentially, her doctor recommended she be placed on light duty because of the back issue she was experiencing, because she was unable to move around as she normally is at the school resource officer position. It's also SRO Liska's position that she was never given, she never had a conversation with any of the people the department alleges she had a conversation with about the attendance issue. Was all about the rumors with the inappropriate relationship with Officer Eklund. And indeed, there's also been some information relayed to me that all the SROs had to go through the expectations individually after she was placed on administrative leave. They had to sign forms indicating they understood the expectations. And again, that was done after she was placed on administrative leave, and I don't believe that she's ever had to do that up to today.
And if I could interject, doesn't it make sense that we would make sure the rest of the SLOs are aware of the rule that was just been violated so flagrantly? Doesn't it make sense that we would tell the officers, hey, by the way, in case you missed this, you were told this, and remind them so that we can hold them accountable as well?
I need a clarification. In between where you talk about the admin duty caused her injury, and it says something about she never had a conversation with.
The department has said on multiple occasions that she was warned, and it's her position that she was never given warnings about the attendance issue until she was given the policy violation notices on January 18th.
Okay.
So I believe it was Commander Runge and Lieutenant Brester have said multiple times that they've talked to her about the attendance specifically, and based on her best recollection of those conversations, it was always about the inappropriate alleged inappropriate relationship with Officer Eklund and those rumors.
Were they documented? Were those conversations documented by Runge?
The conversations were not documented, but I draw your attention to her statement in the investigation that discusses that.
Okay.
At this point, I think if you guys are done answering or asking questions, then you go into a closed session for deliberation.
Are there any more questions of either side? All right. Committee may convene in closed session pursuant to state statute 19.85 sub 1 sub a for the purpose of deliberating concerning a case which was the subject of any judicial or quasi-judicial trial or hearing before that governmental body. The committee may thereafter reconvene in open session pursuant to state statute 19.85 sub 2 to report any actions taken during closed session and consider all other matters on the agenda. So we will be going into closed session. I'm sorry.
I move that we go into closed session.
Okay, motion by Alder Dorf, second by Alder Veronica Dax. All in favor?
Aye.
Any opposed? That's unanimous.
By who, Barb?
Yeah.
By Alder Dorf to go back into open session, second by Alder Veronica Dax. All in favor?
Aye.
Any opposed? That passes unanimously. Okay, this committee did not consider anything other than consideration with possible action on a review of standards of conduct, SRO expectations grievance filed by Officer Tracy Liska. The committee has made the following findings of fact. 1, this matter was heard by the Personnel Committee at their next regularly scheduled meeting following receipt of the grievance pursuant to Article 3 of the Labor Agreement. 2, the parties were provided an opportunity to submit written documentation in support of their positions. Attorney Winford also submitted 4 documents during the hearing, and we labeled those 1, 2, 3, and 4. 4, all the documents were admitted into the record and considered by the Personnel Committee in making their decision. Officer Liska requested a fact-finding hearing, and the Personnel Committee determined that a hearing was not required in this matter. Officer Liska was tardy in reporting to the schools in her assigned school resource officer quadrant on at least 9 occasions. Number 6, instead of being on time to her assigned school, Officer Liska met with another officer outside of her assigned school district area of responsibility on a regular basis. Number 7, all of these meetings occurred when Officer Liska knew or should have known that her duty assignment was to be at her assigned school. 8, Officer Liska was aware of the policies of the Green Bay Police Department as well as the expectations for officers assigned to SRO duties. Number 9.
Oh, yeah, sorry, you're right.
Yep. Green Bay Police Department Policy 320.5.7 Sub A provides the standards of conduct, efficiency, neglect of duty. Number 10. Green Bay Police Department Policy 320.5.7 Sub B provides the standards of conduct, efficiency, unsatisfactory work performance, including but not limited to failure, incompetence, inefficiency, or delay in performing and/or carrying out proper orders, work assignments, or the instructions of supervisors without a reasonable and bona fide excuse. 11. Green Bay Police Department Policy 320.5.5 Sub B provides the standards of conduct, attendance, unexcused or unauthorized absence or tardiness. Conclusions of law. This grievance is properly before the Personnel Committee pursuant to Article 3 of the Labor Agreement. Number 2, a hearing on this matter was timely conducted in accordance with Article 3 of the Labor Agreement. Number 3, Officer Liska's conduct in being tardy to her assigned school on at least 9 occasions constitutes a violation of Policy 320.5.5 Sub B. Number 4, Officer Liska's conduct in meeting with another officer outside of her assigned school district area of responsibility instead of being on time to her assigned school constitutes a violation of Policy 320.5.7 Sub A and 320.5.7 Sub B. I will now take a motion to deny the grievance and uphold the chief's findings.
I will so make that motion.
Motion by Alder LaFave to deny the grievance and uphold the chief's findings, seconded by Alder Corpus Dax. All in favor?
Aye.
Aye. Any opposed? That is unanimous. And this portion of the meeting is concluded.
Thank you.
Are you ready now? Ready? Okay. Under F, number 1, report of routine personnel actions for regular employees. Staff?
This is our standard report that's presented at each committee member, or each committee meeting, detailing transfers and hires, promotions, terminations, and retirements.
Does anyone have any questions on that? All in favor of receiving and placing on file the report of routine personnel actions?
Do you need a motion?
Oh, I need a motion.
How about I move that we receive and place on file?
There we go.
Second.
Second, okay, motion by Alder Dorf to receive and place on file, second by Alder Corpus Dax. All in favor?
Aye.
Any opposed? That passes unanimously.
State.
Number 2, next meeting date, July 10th, 2018. All
So
right.
we have to take the June 26th one off.
We were told that we can't delete those items, but we'll note canceled.
Oh,
Oh.
okay.
Okay, so
So do you have to,
Do we have to-
move it, it's canceled? No.
it's canceled.
Okay.
Yep. All right. All right.
Motion to adjourn?
The motion.
Second.
Yep. Motion to adjourn by Alder Corpus Dax, seconded by Alder Dorf. All in favor?
Aye.
Any opposed? All right.
We have to leave the meeting, so nobody forget that. It's my job to remind everybody of that. It's messed up.